Warm welcome to this morning's Construction and Engineering webinar, which is our winter update for members of the Chartered Institution of Civil Engineering Surveyors. My name is Stefan Harris-Wright. I'm a partner in the Construction and Engineering team at Birketts Solicitors. Once again, many thanks to the CICES for inviting us to present to you this morning. Regular viewers amongst you will know that we've done a few of these sessions for the membership over the years, but we're always very happy to do so and grateful to be asked back. If we could have the next slide, please. So I am joined this morning by three colleagues from my team who are going to present their individual sections, and then they're going to join me again at the end for the panel segment. So with me this morning, I've got my colleagues Patrick Cooney, George Elliman, and Sarah Prior. Next slide, please. So hopefully most of you will have come across Birketts before, and I won't give you the hard sell, but just in case you haven't come across us previously, there's a little bit of information for you at a glance on this slide. But just in summary, we're a full service top 50 UK law firm, and as part of the organisation, we've got a specialist construction and engineering team of 15 colleagues, and we advise on transactional, so non-contentious and contentious dispute-related construction matters. If we could have the next slide, please, and move on to the summary. So just briefly then to kind of cover off what we're going to deal with in this morning's session. So Patrick's going to provide you with an update on net zero building standards. George has got some information and an update for you on the new fair pay initiative in the construction industry. And then we'll hand over to Sarah, who's got our traditional update for you on some recent interesting and significant construction and engineering cases, and then we'll all come back together at the end for a panel discussion and a Q&A. So just before we get into kind of the meat of the presentations, there's just a few housekeeping points for you. There is an opportunity for you to put your questions to our panel for us to go through at the end. So if you could use the questions function in the Teams portal to do that. Those come through to me anonymously, so please don't be shy. Always good to have your questions for our colleagues. We've had a great turnout this morning, and we'll try and get through as many questions as we can in the time available. But I'll draw proceedings to a close promptly by midday. And just finally, the session's being recorded, so you will get a copy of the slides and the recording from the team at the CICES afterwards. Okay, if we could move on to the next slide, please. And without further ado, I will hand you over to Patrick for the first part of the session.
Thank you, Stefan, and good morning, everyone. I'm going to talk about, give you an overview of the new net zero building standard in the industry, and then have a look at how net zero and sustainability type obligations are being filtered down into construction contracts, specifically the NEC, which deals with these things in a much more sort of detailed way than other forms. So if we could have the next slide, please. Before I went on to talk about this new standard and net zero generally, I wanted to just say a few words about the background to put it all into context. So in 2021, that's when the government published the target, which is so much in the news, of hitting net zero by 2050. And the background to that was that the government had committed to various climate change obligations in the Climate Change Act of 2008. And then there was an international treaty on climate change in 2016, the Paris Agreement, with some much more sort of robust obligations. And you might have seen reference to the 1.5 degrees target. That's the objective of keeping the increase in the Earth's temperature to no more than 1.5 degrees above pre-industrial levels. That all came out of the Paris Agreement in 2016. So that's where these targets sort of come from and are set out formally. Then in 2022, there was a challenge against the government brought by environmental groups such as Friends of the Earth and others, multiple claimants, and they challenged the government's net zero strategy and said the plans which are in place are wholly inadequate and you'll never hit net zero by 2050. And the High Court agreed. So that led to, in 2023, Powering Up Britain, which is what set out the revised and much more detailed steps which the government was going to take to meet its net zero target. There were two main documents effectively coming out of that. One was called the Energy Security Plan, and then the other one was called the Net Zero Growth Plan. On to the next slide, please. The Energy Security Plan is all about doubling the country's electricity generation capacity and decarbonising the power sector fully by 2030. And then the Net Zero Growth Plan sets out the specific steps that the government will take in order to achieve net zero. So it talks about specific fossil types and how much of our energy is going to come in what percentages and what's going to be invested where. So some quite detailed steps. Certainly as compared to the 2021 plan, which was successfully challenged. And then at the bottom of the slide there, a new government department was created, Department for Energy Security and Net Zero, whose role it is to deliver on all these commitments, ensure it's achieved, and also maximising the many economic opportunities which will come out of the transition to net zero. So let's move on to the next slide and have a look at the new net zero carbon building standard. So what's this all about? Well, it's been obvious for a number of years that the industry needed a unified definition and methodology around net zero. There has never been a unified definition around what it means and no common methodology for assessing how net zero is measured or achieved. So all of that leads to a lack of confidence really in any net zero claims which are made. So the industry has collaborated to create a unified standard for measuring net zero on a building effectively. And I've said industry collaboration because it's been there's been input from all sorts of industry bodies like REBA, RICS, leading developers, contractors, consultants to create this standard. The full title is the UK Net Zero Carbon Building Standard, just the standard for short, which I put on the slide there. Now, it's currently in its pilot testing phase, or the pilot has just launched rather, and early next year the pilot testing phase will begin. And if you go onto their website, you can actually register for the pilot scheme. And take part in the trial effectively. And then the full scheme is intended to come into force in late 2025. And it applies to a huge range of buildings, very wide application. The one big sort of absence, I suppose, I've put on the slide there is it doesn't currently apply to infrastructure projects, which are of course some of the biggest projects carried out. So that'd be interesting to see what happens there. But in terms of the buildings it's going to apply to, it's very wide indeed. There's not really time today to talk about the specific sort of criteria and methodology, but essentially that is what's being brought in, a unified and singular approach for measuring the carbon output on a building and determining whether it can be labelled as net zero. They talk about a whole life approach. What they mean by that is it takes account of carbon emitted during the non-operational phase of the building. So, emissions created during the sort of construction phase, demolition, refitting, all of that. And then also during the operational phase. So that's when the building would be occupied. So carbon emitted during heating, cooling, ventilation, that sort of thing. So the building must be in use for a year before being assessed, essentially. So the 12 months of data are captured. You can't self-certify. The intention is that an independent, third party will be the assessor, like a sort of contract administrator type approach. And then if the building sort of meets all of the methodology and criteria to be determined net zero, then it can be publicly declared as compliant. And the idea is that you would be assessed on an annual basis. So if you then fall short in later years, you can no longer publicize that you have a net zero building, although you can publicize that you did in the years that you passed effectively. So for the first time, a single set of sort of methodology, criteria, and a singular definition to give real certainty and confidence about what it means when someone says we are developing have developed a net zero building. On the legal side, we're expecting to see certainly objectives to meet this standard when it comes in next year, if not more formal contractual obligations to meet it. And I expect it may well be something which is scored in tender processes as well, given the focus on this in the industry. If we move on to the next slide, I just wanted to have a look at a slightly different angle. So how sustainability, net zero, these principles are reflected or being filtered down into construction contracts. Now I focused on NEC because NEC deals with this in quite a detailed and proactive way, as the NEC does. So you may be familiar with the structure of NEC contracts, but its X options are the optional clauses, and X29 is all about climate change. And there are three main components to it, three main concepts on the slide there. There's the CCRs, the climate change requirements, the climate change plan, and then the separate concept of a performance table, which is an incentivization table. So if we move on to the next slide, we can have a look at each of those concepts in overview. So the climate change requirements are part of the scope. So they are like the employers' requirements. I'm sort of defaulting to JCT sort of speak there, but they are the obligations on the contractor around climate change, whatever they may be. And because they're part of the scope, if the contractor doesn't meet them, that's a defect. So it's something that has to be corrected under the contract. So it has real teeth by being part of the scope. What sort of things could be, could form part or could be the climate change requirements? Well, I mean, that's going to be very client specific in terms of what is important to you, and it's going to be very project specific. But the guidance notes are quite good. The NEC's notes talk about the sorts of things you may want to include: levels of recycling, use of renewable power on site, use of electric vehicles on site, reducing waste generation, designs which reduce carbon emissions. All of those things could feed in and be part of the climate change requirements, which the contractor has to comply with. The NEC makes a good point in its drafting notes that they need to be carefully drafted so that they're measurable and achievable. We see no end of disputes around aspects of scope or contractual obligations where it's just not very clear what needs to be achieved, and it's quite subjective. So if you're going to use these, make sure it's quite clear what needs to be done from an objective perspective. But equally, you don't want to fall so far of the other side of the line and make them so onerous that they will just deter contractors from bidding at all. So that's the climate change requirements. Then the flip side to those, or the sort of part two of those, is on the next slide. Thank you. Which is the climate change plan. So if the CCRs are the specific obligations on the contractor, the climate change plan is like the statement of intent. It's the contractor's strategy for actually achieving the CCRs. So this is very NEC. It's a very proactive approach, and making sure that things actually happen to make sure that the contract intention is met. they don't have the same sort of force, as it were, as the CCRs in terms of they're sort of standing under the contract, that the plan is not part of the scope. So there's no specific sanction if the contractor doesn't comply with the climate change plan, with its own climate change plan. But as we saw in the last slide, failing to meet the climate change requirements is a breach. So in practice, it may well be that you're not complying with the plan, then you're probably not meeting the CCRs. So you're ending up in a sort of defect scenario by hook or by crook. But they're not specifically part of the scope. The plan is not. And then if we have a look at the next slide, there's a related but separate concept of the performance table. So this is very NEC. The performance table is an incentivization table, effectively, around climate change obligations, different from the climate change requirements, or you could feed them into the table. Basically, it's a set of targets that you set out in the table, and then you attach positive or negative incentives to meeting or falling short of those targets. So if you're very NEC with the methodology, you'd probably attach use the carrot approach and attach a positive incentive, but equally it could be financial negative for not hitting the target. It's worth noting that the performance table is not part of X18. It sits out of option X18, which is the limit of liability. So these are excluded matters. So anything in this table, it would not fall within a liability cap unless you specifically amended the contract. And as I say, they are different, these targets, from the CCRs. Failing to achieve them isn't a defect in the same way as it is for the CCRs, but you do have those financial incentives, or whatever incentives you may choose, attached to them. And again, the guidance notes are quite practical. They recommend that the target should be objectively measurable, and again, this is something we see a lot, and avoid the use of subjective phrases like you must do X and do it to the employer's reasonable satisfaction. Very vague and very unclear as to when that target's been achieved, and when the incentive should kick in. And again, the guidance notes say make sure that the targets are objectively measurable, and it's quite practical. In the notes, there's a recommended sort of matters which you could set out in the table. The subject matter of the target itself, how it's measured, when you're going to assess performance, that sort of thing. So quite a practical approach, and very, very NEC, very, very, very incentive based. No specific industry standards incorporated, but you may wish to attach meeting certain known industry standards like BREEAM or BREEAM. I never know how that's pronounced. People seem to say it both ways. I'm going to cover myself there. So you're sort of free rein there. So onto the last slide. Why is all this good? What are the benefits of all of this? Well, clearly, buildings which have good ESG ratings are going to be attractive to occupiers and funders. It's good for recruitment, retention. Working for a company that's actively trying to protect the environment is going to be attractive to employees. Obviously good PR. A building with green credentials, you would expect to attract a premium price. And then the fundamental point to this, and the net zero standard and the net zero principle more widely, is this is about the wider social benefit of the industry's collaboration to try and achieve net zero and improve sustainability. And by including these clauses and then furthering them by passing them down to subcontracts, you're really helping to mitigate the impact of construction on the environment. Okay, so that was a quick overview of net zero and related topics. I'm going to hand over to George, who's going to talk to you about fair payment.
Thanks, Patrick. So fair payment, and this topic is relevant in the context of the new Labour government at the moment. which is why we decided to speak about it. They've announced a replacement for the prompt payment code, the fair payment code, similar name, roughly similar effect. That's going to come in at some point before the end of the year. That's all we really know at the moment. Obviously, end of the year is coming up very quickly, so that is imminent. The point to underline, though, is that fair payment, late payment, as we all know in the construction industry, are very live issues, very regular topics of discussion, and the construction industry itself lends itself to those kinds of issues being particularly important. So we're thinking about things like the unique multi-tier contracting structure that we have in construction. We're thinking about potential negotiating disparity between the sort of larger clients, larger contractors, and further down the supply chain. And things like procurement lead times are exposing different people in that supply chain to different levels of risk at different times. So late payment, fair payment has a particular resonance for us in the industry because of the potential impact that it can have. Next slide, please. So I thought the best place to start on this would be a very quick run through of what we would tend to call the sort of legislation toolkit of what small businesses generally and in the construction industry have to tackle fair payment and late payment. And that's an important distinction to make as well between fair payment and late payment. Late payment is bound by the terms of the contract, what you've agreed. Your payment terms could be very long, but if you're paid on time, that's not late payment. Fair payment encapsulates a wider set of circumstances and includes the actual base payment terms that you're agreeing to. They may be agreed by both parties, but ultimately the payment periods are unfair. So the first one to mention is the Late Payment of Commercial Debts Act in 1998. So in the absence of any other clauses in a contract, this introduced the statutory implied terms of the right to claim interest on late payment, and that runs from 30 days after the agreed payment date for public and 60 days in the private sector. So that's a powerful tool to have. In the construction industry specifically, we've got the Construction Act in 1996, brought in, as well as the standard set of payment terms that need to be included in all construction contracts. You also have the right in there to suspend works and services for non-payment. Next slide, please. And then in 2015, we have these compulsory reporting requirements, which does specifically go to fair payment, in that this requires companies and LLPs of a certain size to report on their payment practices and their standard terms and performance against those requirements. And that included a criminal offence by businesses if they don't report as they're required to under these regulations. And the applicability of this regulation is limited to the companies that would fall within the requirements of a medium company under the Companies Act. So there you're looking at turnover over a certain level, employee count over a certain level, balance sheet for certain periods of the year being over a certain level. So it's not absolute applicability to everybody, but it captures quite a lot of companies in reporting these things. Next slide, please. And then specifically on fair payment, the government in 2008 introduced the Prompt Payment Code, which was designed to set these minimum standards and the overarching ethos for how people are paid, what kind of terms we deem commercially acceptable and ethically acceptable across all business to business and public sector to business contracts. And it was fairly light touch for the first 13 years that it was in place. But then in 2021, the government introduced some new requirements, which increased the protections for small businesses, beefed up the reporting requirements, going beyond what the regulations in 2015 included, and just generally improved the effectiveness of the code. And the most important one there is you'll see the 95% of invoices to be paid within 60 days. 2021, they introduced this requirement for 95% of invoices from small businesses, so under 50 employees, to be paid within 30 days. So significant shortening where it was needed the most. The Prompt Payment Code is enforced by the Prompt Payment Code Compliance Board. They investigate circumstances of non-compliance. They receive the reports on whether the code is being met by the people who signed up to it, and then where they feel it's necessary, they can suspend or permanently remove companies from the Prompt Payment Code for failing to meet those requirements. Next slide, please. Which brings us to the Fair Payment Code, which was announced in September 2024. And like I said, we're expecting that to be fleshed out in more detail and brought into force by the end of 2024. It's coming up quite quickly. Whether it may slip to 2025, it may well do. I suspect the government's been very busy with budget-related things over the last month or so. So whether we do get that in 2024 remains to be seen, but it's coming soon regardless. And this replaces the Prompt Payment Code. But I think the thing to stress is that in core details, it will not vary too much from what we currently see. So the 2021 reforms to the Prompt Payment Code were well received and they've been a success. And I strongly suspect, and certainly from the information we've had on the new Fair Payment Code, is it's going to contain quite a lot of the same kinds of provisions. So we're thinking about senior director buy-in, we're thinking about potential auditing, we're thinking about making a distinction between small businesses, larger businesses. What's acceptable for one may not be acceptable for the other. So all of those features of the 2021 reforms are likely to carry through, maybe be strengthened a little bit in the new code. And the core purpose of this new code is to improve on some of the main stakeholder complaints that have been made about the Prompt Payment Code. And they tend to go to accountability, enforcement, and a suspicion that there's an element of lip service in being a signatory to the code that maybe doesn't flow through into actual action. So there's certainly a disparity that we can see between the companies that are signed up to the code, the frequency of suspensions or removals from the list of signatories, and then the actual on-the-ground reports from those working on construction projects about how regularly they're not paid on time or they're subject to unfair payment terms. Next slide, please. So this is one of the more novel changes that the Fair Payment Code is going to introduce compared to the Prompt Payment Code, and this is this sort of three-tiered award system around attaining certain levels of fair payment against the requirements. So you'll see there that you have a bronze level, 95% of suppliers paid within 60 days, then silver, 95% paid within 30 days, remaining suppliers paid within 60 days, and then gold, 95% of suppliers paid within 30 days. Now the gold award there is a significant step forward from the Prompt Payment Code because it takes the majority of payments made and terms agreed into a greater level than the Prompt Payment Code expected. The slight downside there is that the bronze level is, on the face of it, a weakening of the requirements of the Prompt Payment Code. And quite how they navigate that will be interesting to see, because on the one hand, you'd expect this to become the sort of gamified competitive environment where the companies that are signed up to it want to achieve gold level. But bronze is still an award. And are we incentivizing the right actions if we're saying you can have an award if you pay your suppliers within 60 days? Is that a step backwards? It'll be interesting to see what the actual code includes on that, whether it will be that clear cut. But certainly the hope will be that gold is going to be the standard that all these companies are going to be striving for. It's what they're going to want to be able to put into their tender submissions. It's what will be the norm essentially. And on the flip side of that, you would expect they would hope the bronze award to become, if not a PR disaster, then something that those people signed up to want to avoid. Next slide, please. So these measures go essentially to the two of the key points I mentioned a couple of slides back, which are the stakeholder complaints with the prompt payment code as it currently stands, which is enforcement and compliance and accountability. So one other point in addition to the actual code itself that the government's announced is strengthening the enforcement of the code. What that may include is potentially a slightly more active investigation auditing process. Sometimes with the prompt payment code, there's a feeling that it's a very sort of self-policing structure. The compliance board will review the reports that comes into it, but they don't proactively go out, assess compliance, take measures based on those proactive investigations. So potentially something coming in that might strengthen those. And then the other thing is potentially widening the scope of the reporting requirements and maintaining some level of individual accountability for the directors who are signing on to the report. And the final point there, one of the parts of the announcement from the government that includes arguably the least information, but a consultation is coming down the line after the Fair Payment Code about further measures that could be brought in to improve fair payment in the industry. And it'll be interesting to see what that includes. Next slide, please. So some final thoughts. First is that the direction of travel is towards more control over payment periods and favouring the victims of late payment and the small businesses within a contracting structure. First one I mentioned is the EU late payment regulations. Now, for obvious reasons, this doesn't directly come down into UK law anymore, but that's a regulation that brings in a 30-day payment term for all commercial transactions, which is really significant. It's important to us because large clients, large contractors, they may have UK and European breadth. And if they are going through administrative steps to make their finance teams work with a 30-day payment period, and if they are wanting to target the gold standard under the new Fair Payment Code, then this all ties into that becoming almost an easier approach to take across the board than to selectively meet the regulation on certain projects and then in the UK meet a lesser standard. So there's a certain amount of alignment there that I think we will actually see in practice. Second point to flag is just around the Court of Appeal decision in Providence v Hexagon. So this was a case that we reported on in our autumn case law update. And that effectively goes to how we interpret the termination clauses in JST contracts for repeated late payment. And the Court of Appeal decision that came out in favour of the unpaid party. They were entitled to terminate a contract for repeated late payment, even though the original late payment breach had been rectified. So that's, as it stands, quite a powerful interpretation. It's only one interpretation rather than a pattern, but it's a good example of how the courts might interpret these kinds of clauses. And the final point from me is just to watch this space. As I've said, this is coming very soon, so keep an eye out, and I'm sure we'll have an article out when the Fair Payment Code does come into force with more details. And now I will pass over to Sarah, who will give the case law update.
Thank you, George, and good morning all. Today I'll be discussing some of the recent case law decided in the last few months. Next slide, please. So first is the eagerly awaited decision from the Supreme Court in the case between Abbey versus Simply Construct, where it was finally held that a collateral warranty will not typically be a construction contract for the purposes of the Construction Act. The background was that Simply was appointed by the employer Sapphire Building Services under a JCT D&B to design and build a 65-bedroom care home in Mill Hill, London. Abbey was the tenant operating the care home business from the property. Simply initially provided a collector warranty to the owner of the property, Toppin. Simply then provided a collector warranty to Abbey in its capacity as tenant of the building. Although it is important to note that this warranty was not provided until 2020, long after the works had been completed. Toppin discovered fire safety defects at the property and notified Simply accordingly, asking Simply to rectify those defects. Simply failed to do that, and so Toppin employed another contractor to remedy those defects. Abbey paid for the cost of the remedial works on behalf of Toppin. Both Toppin and Abbey commenced adjudication proceedings against Simply for costs associated with the fire safety defects, sums of 8.8 million and 5.5 million respectively. The adjudicator agreed that Simply was liable and awarded Toppin damages for the cost of those remedial works, and Abbey lost profits resulting from those defects. Simply didn't pay, and Abbey sought to enforce the adjudicator's decision at the TCC. Next slide, please. So it was held by, oh, I think we're on the wrong slide there, Natalie. Yeah, we're still on. We need to go a little bit further on. There we go. So it was held by the TCC that a collateral warranty was not a construction contract for the purposes of the Act, and so the adjudicator had no jurisdiction to decide the dispute. His decision in respect of sums due to Abbey was therefore unenforceable. Abbey appealed, and the decision was subsequently overturned by the Court of Appeal in June 2022. However, in December of the same year, leave was granted, allowing Simply to appeal the decision to the Supreme Court. In hearing the appeal, the Supreme Court was asked to consider whether a collateral warranty is a construction contract within the meaning of Section 104(1) of the Construction Act. This raised two issues. One, the statutory interpretation, namely, what is the meaning of an agreement for the carrying out of construction operations for the purposes of the Act, and two, the contractual interpretation, i.e. whether the collateral warranty issued to Abbey was an agreement for the carrying out of construction operations. The Supreme Court unanimously held that a collateral warranty was not a contract for construction operations unless it contained an express obligation to carry out construction operations for a beneficiary under the original contract or appointment being warranted. The collateral warranty issued to Abbey simply replicated undertakings given in the original building contract rather than any separate or distinct undertakings for the carrying out of construction operations. As such, it was not a construction contract for the purposes of the Act. The adjudicator did not have jurisdiction to decide the dispute referred by Abbey, and the appeal was allowed. Next slide, please. So, what can we learn from this? There are two things. Firstly, most collateral warranties will not be construed as a construction contract for the purposes of the Act. If a dispute does arise, any claim under a collateral warranty, it will need to be resolved through the courts, which could be both costly and timely. Secondly, if a party wishes to have the benefit of adjudication as a method of dispute resolution, they will need to either, one, include careful consideration to the drafting of the warranty and include distinct or separate undertakings in the collateral warranty which give rise to separate undertakings for the carrying out of construction operations over and above those contained in the underlying building contract or appointment, whatever the case may be, and also include a specific right to adjudicate in the warranty itself. Next slide, please. So next up is a Scottish case of ATG versus Ogilvy Construction, where Ogilvy employed ATG as a subby for a groundworks package at New Mills Road, Dalkeith, for the development of 50 homes and a 40-bed care facility. ATG submitted an application for payment for the sum of just over 1 million, which Ogilvy failed to respond to. ATG subsequently referred a dispute to adjudication after Ogilvy failed to pay the sum applied for. Next slide, please. The adjudicator was asked to decide if ATG had submitted a valid payment application for payment. The subcontract required that the parties serve all notices by first-class recorded delivery to the address stated within the subcontract. However, it was agreed at a further pre-contract meeting between the parties that payment applications could be sent by email to Ogilvy at 2 specified email addresses. This particular application for payment was sent to a different email address, although to Ogilvy. Whilst Ogilvy did not argue that the application had not been received, they argued that it had been invalidly served and not in accordance with their subcontract. The adjudicator disagreed and held that ATG's payment application had been validly served. In making this decision, the adjudicator relied on the decision in the Jowerby property case. This case provides authority for the principle that applications served other than in accordance with the provisions of the contract are still valid, where the parties have adopted a course of conduct which treated them as such. So because Ogilvy had not issued a payment notice, nor had they issued a valid payless notice, the final date for payment had passed without full and proper payment in respect of the application. Ogilvy was ordered to pay the application in full within 7 days. Next slide, please. Ogilvy failed to pay the sum awarded, and ATG commenced enforcement proceedings to recover the sum due. In defending the application, Ogilvy argued that the decision of the adjudicator was wrong. They stated that the adjudicator had materially breached the rules of natural justice, as the subcontract required that the notices were to be served by first-class recorded delivery posted to a stipulated address. Further, Ogilvy argued that the adjudicator had gone off on a frolic in applying the Jowerby case, including that he considered an English case law when the contract and adjudication were subject to Scottish law. The judge found that Ogilvy's defence was entirely without merit, and that the adjudicator did not go off on a frolic of his own, and that the adjudicator was entitled to rely on ATG's submissions and look at English court decisions, including Jowerby, which exemplified the principle that ATG were arguing before the adjudicator. The judge criticised Ogilvy for mounting a frivolous defence. Next slide, please. So even though this case was decided under Scottish law, it does reinforce the importance of submitting valid payment and payless notices in challenging applications for payment. Again, the decision highlights the pay now, argue later principles which underpin the payment provisions of the Construction Act. As previously stated, the judge was clear here about ignoring reminders and mounting frivolous defences to avoid payment, which constitutes unreasonable behaviour and the cost consequences that brings. Next slide, please. So our final case today is between Beck Interiors and Eros. Eros employed Beck as a fit-out contractor for the new Mandarin Oriental Hotel at Hanover Square in Mayfair. Over a 13-day period, Eros issued 4 separate adjudications against Beck for sums exceeding 34 million. Beck applied to the TCC for an injunction to prevent Eros from issuing any further adjudications against them unless they first obtained permission from the judge at the TCC. Beck also sought an order that Eros be compelled to withdraw the 4 adjudication notices. Next slide, please. The judge recognised that whilst it was a burden to have to deal with 4 adjudications in such a short space of time, Eros nevertheless had a statutory right to adjudicate at any time. The judge found that there was no unconscionable or unreasonable or oppressive behaviour in Eros's approach to the individual adjudications, and that it is rare for the court to interfere in the adjudication process by way of injunctive relief. On this basis, the application for adjunctive relief was refused. Next slide, please. This case reinforces the court's reluctance to intervene in adjudications and that it will only do so in exceptional circumstances. This was not an exceptional case that merited the intervention of the court. So thank you all for listening. I will now pass you back to Stefan for the Q&A session.
Thanks very much, Sarah. Good stuff. Right, so we have got almost 15 minutes available, should we need it, for our Q&A session, and we've had some questions in, so thank you very much for those. Okay, so Patrick, I will start with you. We've had some questions in about net zero. First one here, so we hear so many different definitions around net zero. Is there a difference between net zero and carbon neutral?
Well, they're similar, but slightly different. I suppose the two differences are carbon neutral is only talking about carbon emissions. And although we often only talk about carbon emissions in achieving net zero, it's about reducing emissions of all greenhouse gases. Carbon is just one of them. Methane is another, nitrous oxide is another. There are quite a few. Carbon's just the big one. And I suppose the other difference is when you talk about carbon neutrality, that I think most people would understand that to mean that you can still emit carbon, but use other techniques, for want of a better word, like carbon offsetting to net off your emissions. So you can still be producing carbon, but you can offset that production by, say, investing in reforestation to reabsorb CO2 from the atmosphere. So with offsetting, you are reducing CO2 levels, but it's not really about truly net zero, which is reducing your emissions in the first place. Carbon neutral allows for still emitting in an industrial process, but then using other techniques to bring that to capture that carbon and bring it back down again. So I think true net zero doesn't allow for offsetting. It's about not emitting in the first place, not contributing at all.
Good stuff. Thanks, Patrick. George, if I come to you next. Question about the legislation around the things that you were discussing. So the question is, what new legislation is likely to come out of the consultation?
Yeah, it's an interesting one, and it's difficult to say without much more information from the government about what they're intending. My instinct would be that they would like to keep the Fair Payment Code itself quite positive, quite target and action orientated on exactly what those fair payment provisions need to be. To the extent they end up really strengthening the enforcement and the auditing of companies, I suspect that would be something that they would deal with in consultation and in new legislation potentially.
Great stuff. Thanks, George. Patrick, if I come back to you now, question around the contrast between approaches of NEC and JCT. Interesting to see how the NEC is addressing climate change. Does the JCT have similar clauses?
Well, the answer to that is it does have clauses on sustainability, but they're nowhere near as involved or detailed or as sort of practical as the NEC provisions. So there are, in the new 2024 suite, there are clauses which allow the contract in JCT, the contractor to suggest improvements to the works which may enhance sustainability, for example. That's the main one. But there's nothing like the detailed regime that there is in NEC. And in fact, the NEC 2024 clauses are not actually new. They've brought them up front, as it were, into the sort of main conditions of the JCT, but the same clauses used to appear as a supplemental condition in the old condition, so they're not really new. But yeah, nowhere near as detailed as the NEC, and so nothing comparable.
Good stuff. Thanks, Patrick. George, if I come back to you, question here: is there a place for more extended use of project bank accounts do you think?
So project bank accounts, PBAs, for those who don't know, is a concept we have where the money being paid to the supply chain is put into one centralized bank account and is then paid concurrently with the entire supply chain on a construction project. There is a chance that we get some more widening of project bank accounts, but it would only be limited, I think, to certain public sector projects. I don't expect the government will go any further than that. They are very good at reducing the payment timeframes at the expense of a loss of a bit of control by the client in terms of how the cash flow is paid out. I know it's definitely true in some of the devolved countries that public sector projects require a project bank account. And I know there was an attempt by I believe it was a Labour MP during the last government to amend the new Procurement Act to include some provisions around project bank accounts and a financial threshold for bringing those in. I suspect that if they did do any more, it would be in the form of that kind of legislation. Anything further than that in private sector, I think, is unlikely beyond just making them more accessible and a better option. That's as far as I think they would go.
Okay, thank you, George. Patrick, back to you on net zero again and clean energy. So question here around nuclear. Is nuclear considered to be a clean energy source?
Interesting question. I think you have to consider it a clean energy source because in its production processes, nuclear emits almost zero carbon and emissions or greenhouse gases. So certainly in its processes, it is. I mean, there is an obvious but to that, which is in the context of an accident, and the climate is still recovering from the effects of Chernobyl and Fukushima, but there's not been an accident for a long time, so I think you'd have to classify it as clean based on its production, but it is a fairly controversial subject, and I'm sure that there are environmental groups wouldn't agree with that, but difficult one.
Good stuff. Okay, well, we've got plenty of time. We've got one more question for the group, unless anybody feels that they want to chuck any more questions in before we go. But at the moment, there's just one more to cover. Patrick, it's another one for you. So it is to do with targets for net zero. So what are the government plans / targets for the power sector to be net zero by 2030? A big question.
Yeah, that is a big question. So it's probably worth just putting into context the 2030 target. So I talked about net zero and the global commitment to achieve net zero by 2050, but you do read a lot about achieving X by 2030, and I mentioned that we as a country have committed to decarbonising the power sector by 2030. So what's the relevance of that? Well, 2050 is the agreed international target for achieving net zero. So that's the global target. And then to achieve that, global CO2 emissions need to reduce by at least 50% by 2030 if the 2050 target is to be achieved. And in fact, under the Paris Agreement, which I mentioned earlier in the slides, we, the UK, committed to reducing our carbon emissions by 68% by 2030. So there are a lot of sub-deadlines, as it were, around 2030 in order to achieve the global 2050 target. An obvious one which will affect us all is the ban on sale of new petrol and diesel cars and vans in 2030. That went up to 2035 under the previous government, and the new government has brought that back down to 2030. And then in terms of electricity generation and decarbonising that sector by 2030, well, I mean, essentially, it's about it's significant investment in clean energy sources. So you're looking at significant investment in wind and solar. So the detail of all of this is set out in a Labour policy document. If you search for five missions for building better Britain or something like that, you'll bring up the Labour policy document, which has all the detail. You have to get through the bit at the beginning when they sort of criticise the previous government very heavily. That sort of have to do that, and then it gets on to it's got some quite good summaries of what they're doing, but they're quadrupling investment in offshore wind. They're investing in floating offshore wind, tripling solar generation, getting the nuclear projects over the line, Hinkley and Sizewell. That's it in a nutshell. It's significant investment in clean energy sources. But have a look at the Labour policy document, which really contains the sort of the fine detail on that.
Great stuff. Thanks, Patrick. Okay, well, we're a little bit early, but we've got through all of the questions that came in. So those of you that were able to come forward with your questions for our assembled panel, yeah, that's kind of just about all we've got time for, really. I hope you found the session useful. Thanks once again to the CICES team for inviting us to present to the members this morning. Thank you all for joining us, from myself and the panel. Have a good day, and we hope to see you next time.